Let's dig deeper now with CNN legal analyst and former New York prosecutor Paul Callan. Paul, appreciate you getting up bright and early for us. So Linsay Graham says that he's protected under the speech and debate clause. He's arguing that he was acting in his capacity as a member of Congress. What do you make of that position?
Well, good morning, Boris. And yeah, boy, it is early, but it's always nice to be with you. Yeah, the speech and debate clause of the Constitution is a very interesting clause and a very important one. And it essentially, when the founding fathers were putting the Constitution together, they decided that members of Congress, when they're engaged in regular legislative duty on the floor of the House or Senate, are immune from arrest or being compelled to testify in other places. There was a fear that they would be yanked off the congressional floor by local authorities and not able to do their job, their federal job. And that's what the court is looking at here. Graham is saying, hey, that phone call that I made to the Secretary of State in Georgia was a legislative purpose. We were looking, as he was, by the way, head of the Judiciary Committee in the Senate. So he's trying to say that he was kind of examining those procedures in connection with potential maybe legislation that could be adopted in Congress. Georgia officials are saying that's complete nonsense because Raffensperger has said in that call, Graham was asking about throwing away some absentee ballots in such a way that might help the Trump candidacy, and that it didn't really have a legislative purpose. It had strictly a political purpose. And so far, Georgia officials have ruled in favor of him having to testify, saying that this looks to be a political purpose, not a legislative purpose.
So stepping back, Paul, the Fulton County DA's office is arguing that delaying his testimony could result in, quote, material injury to the grand jury and its investigation. In the grand scheme of things, how do you see Graham fitting into their case?
Well, I think Graham is an important part of their case because the entire Trump defense, which is being articulated by Giuliani and by the Trump campaign, is essentially that any calls that were made to Georgia were not calls attempting to illegally overturn the election, but were simply examining what had gone on and asking them to be careful that the votes had been counted carefully. So Graham here, though, he's trying to go up into the appellate courts, the federal appellate courts, to stall his testimony. And of course, he's pulled the district court judge who said, no, you have no legitimate argument here. You're going to testify. So he's now gone to the appellate court, and he's hoping that they will issue a stay. Maybe he'll even take a shot at the Supreme Court later on to keep him off the witness stand in Georgia.
What do you think his chances are of success on that appeal in the 11th Circuit?
I don't think his chances are great. The federal judge in the case believes that the state of Georgia has very, very strong arguments here that this is not a legitimate use of the speech and debate clause, and that, in fact, everything indicates that Graham's purpose was political. And there's another argument here that's a very interesting one, is how do you determine whether it's a political purpose or a legislative purpose if you don't get to question the person? So that's one of the arguments that's being asserted by Georgia officials. I think they'll probably get him on the witness stand.
Paul, quickly, I want to get your thoughts while we have you on the investigation at Mar-a-Lago. The Justice Department has until next week, because of this federal judge, to propose redactions to the affidavit that led to the search of former President Trump's home. You have argued that it is in the judge's interest to release the information. Help us understand why.
Well, one of the things you have to think about here is that when the FBI went looking to get this warrant issued, a warrant to search the residence of a former president of the United States, this is a big deal. And the same judge who's hearing these arguments now about public release of the affidavit supporting the application, the probable cause affidavit, is the same judge who made the decision that there was enough to go in and search the residence. So I have to think that the judge probably is releasing or saying that we should release as much of the affidavit as possible because there was strong probable cause supporting the warrant. Otherwise, the judge will be criticizing himself if he's releasing an affidavit that couldn't support the search. So it's kind of in the judge's interest to go a little bit more public with this affidavit to show that the courts were acting properly in the extraordinary circumstance of searching a former president's residence.
Again, prosecutors have until next Thursday to propose those redactions. Paul Callan, we hope you'll come back and give us your legal perspective then. Thanks so much.
Always nice to be here. Thanks, Boris.
Appreciate it.
All right, still